Hi, everybody. Good afternoon. This is Greg Lois. I am with my esteemed partner, Christian Cison today, and we are going to be talking about the drug formulary in New York, which is everybody's favorite topic.
It's pretty intense, yeah.
All right. We are about a month away, a little less than a month away now, from the implementation of the drug formulary. We start to get a ton of questions on this formulary, and we thought this would be a perfect opportunity to give an overview of it. We're going to focus on some of the loopholes that we found in it, some of the problems, and then we are going to try to answer as many of your questions as we possibly can. So we're going to talk about the formulary in general, sort of the things we've observed and what the board is saying about how the formulary is going to work. We're going to talk about how to read the formulary, and in fact, there's a handout today that we're going to go over and kind of show everybody how we think the formulary is going to work. We're going to talk about what the review process is, so when you're getting those prior authorization requests, when we're disputing the need for specific drugs under the formulary, we're going to talk about how that is done, who has to be accredited, how you are, all those things. We're going to talk briefly about the electronic portal, and then we are going to give you as much practical advice as we can and answer as many questions as we can.
What else are we good for?
What else are we here for, really? So our goal is to try to get through an overview of the formulary in about 10 to 15 minutes. We have a lot of slides to sort of plow through, and then to answer as many of your live questions as we can. We're going to ask everyone to type your questions into the box. I have a computer in front of me. I can see the questions popping up, and we'll try to answer as many as we can. We will not say your last name. We'll just say your first name, so you know we're talking to you and answering your question. We're going to try to pick out questions that are going to be useful for the whole group.
Everyone, right.
And
there's already questions coming in, so I know that we won't get to everybody's because this is such a new topic, but we'll be sure to get to everyone's by email after the webinar if we don't get to them today.
Yeah, and a hot topic. I mean, my email has been full of questions about this, so is yours, right?
Yeah.
So I feel like this is the right time to be talking about this. All right, let's do a quick overview. The law changed in April of 2017. Those changes are starting to phase in. Those changes included the adoption or the requirement that the board adopt a formulary, and the formulary is now being divided into a number of different types of medications listed as Phase A, Phase B, perioperative drugs.
Right.
They also have another designation of second-line drugs that we're going to talk about what the heck that means. And then we're going to talk about how the drug formulary interacts with the medical treatment guidelines. So we're going to talk about sort of how all of these things fit together today.
Yeah, if you're wondering why the change came in April 2017, it's because there were 3 comment periods where the actual formulary changed after each one. So we finally have something with an anchoring event coming up, like you mentioned, and we're ready to take on that challenge and see how that affects your cases.
Yeah, the last formulary was issued, I think, November 5th, 2019, right? So that was the adoption and some changes that have come in. The formulary looks pretty simple on the surface. It's only 12 pages, really 11 pages if you don't count the cover. It looks pretty simple, but as we started to answer specific questions about it, realized actually this is pretty complicated stuff and pretty complex. All right, so let's talk about the different levels of drugs. And I'm hoping that everyone has had the opportunity to pull out the handout that we've included in the webinar materials today and take a look through. If this is your first time looking through the actual formulary itself, you realize it looks quite simple. If you're looking at the formulary, and we've got a copy for you. There you go, bud.
Look at that.
It should be the one that says November 5, 2019 on the cover. That's the most recent one. As you're looking through the formulary, they talk about what is a Phase A drug, Phase B drug, all those things. And it's important to note that these phases are going to refer to when we're going to be allowing these drugs to be utilized in the case. So a Phase A drug is one that is listed in the formulary. It is generally going to be used within the first 30 days following the injury or the establishment of the case. Now, it's important to note that the timelines in the formulary start with either the establishment by the board of a claim or the date of injury, whichever is sooner.
Which is funny because when is the establishment going to become before the injury?
Not
right?
possible.
So that it's kind of like a little play here. That's going to be the first 30 days from the injury. Right?
Okay, and those Phase A drugs, you're allowed up to a 30-day supply. Of course, can they come back and request more Phase A drugs? Yeah, but they're going to require our prior approval. So we'll talk about how that works in a second. A Phase B drug, these are drugs that are supposed to be used after the first 30 days. They're on a very specific list, and they follow in general the medical treatment guidelines. Now, interestingly, a phase B drug is going to be allowed for up to 90 days supply at once. And by the way, they can just keep coming back and adding on more 90-day periods.
Sure.
It's allowed under the guidelines. Okay. What if the phase B drug, and this would be the type of maintenance or palliative care drug that we would expect someone to be on for a long period of time.
Right.
I'm thinking of things like muscle relaxers.
This is exactly the drug that you just mentioned, right? The ones where the 90-day supply is out and it's deemed unsuccessful, right? So this is very different from your typical visit to the doctor when you really exhaust all of your medication, you come back and the doctor kind of shakes his or her head and says, I don't know if you need this. We know that doesn't happen in workers' compensation that often, right?
Ever.
So there is now a system here that would allow for second line drugs to be applied. It's going to be a little bit hectic once it gets started, but I think ultimately it might be helpful.
Right, and they specifically say that the second line drug should be prescribed after the first one is proven to be unsuccessful, or there's side effects, or perhaps comorbidities that are preventing the efficacy of that first line drug. All right, so the second line drugs, we just talked about it. This follows a phase B drug. This is where the first line drug is ineffective. There's also a class of drugs labeled perioperative drugs, and this kind of makes sense too. This is medications that we're going to be taking either 4 days before or 4 days after surgery. So I'm imagining all the types of surgical medications, anesthetics,
right.
all sorts.
A lot of your painkillers, post-operative treatment for, or any kind of wound, relaxers. The interesting thing about perioperative, by definition, it's supposed to mean when the person goes in for surgery and when they come out. So leave it to the board to, create a 4-day window before and after to actually give you more of an opportunity to get prescriptions. But
all right, and so far, I would say, this stuff all sorts of made sense, and okay, we're all on the same page. And then the board, of course, because it is the board, goes and creates the special considerations. So these are special considerations where we're going to think maybe the rules do or do not apply based on the actual treatment course. So some special considerations that apply, not, for example, are good for us not to exceed a 7-day supply. This would apply to things like opiates and narcotics. And there are several drugs that are labeled number 1 on the formulary, specifically saying not to exceed a certain amount.
Right. If you guys have the worksheet, the special considerations has its own column with a number attached to it. Most people think of special considerations in our line of work as the schedule loss of use guidelines and adding percentages onto a range of motion deficit. Mm-hmm. Here, it might actually help because it further limits when a formulary drug can be used.
Mm-hmm. Okay. Next is for the prescribed course of therapy. Things like antibiotics, things like we've had an infection in an operated body part. And so we would see maybe that's a special consideration where a special drug would have to be done. Some drugs are identified as short-acting only. And this short-acting only really would be for things like breakthrough pain medication. We don't want to keep people on narcotics, opiates that have a long-lasting effect. So for that reason, they have this special consideration. And then, of course, the board adds a special loophole, which says, quote, anything else as clinically indicated. And specifically, they created this loophole for situations where there is no medical treatment guideline, there is no prescription basis, and really the doctor, the prescriber, is looking for a loophole to sort of throw in, and that's this special consideration.
Right. I would say this is almost like the exception to the exception, where the formulary is designed to make sure that medications are reasonable, and this here is going to be certainly one of contention between our side and the treating doctor.
Yep. All right. So just a quick reminder, this is completely and totally live, so please ask us questions as they come up to you. Okay, when is prior authorization required? Well, it's pretty simple. If the prescribing provider is trying to get something prescribed, that is not listed in the formulary. All right, so wonderful risk professional. I know all our risk professionals have 4, 5, 6 different hats on their heads at all times. You're a litigation manager, you're a social worker, you're an accountant, you're the fiduciary of an insurance carrier and insurer. You have all these roles on your hat, in your head, and now there's another one, which is pharmaceutical expert. So you are supposed to be able to figure out by looking at this formulary if the drug is applied. Now, unfortunately,
that's where your 12-page document kind of goes to shreds here because the fine print is so small to list everything here.
All right, so we get it. This is going to be really tough to figure out. Is the drug listed in the formulary? So that's number one.
It's actually two. I mean, to add to that level of specificity, drugs not listed in the formulary also include drugs that are on the formulary but are not applied in the ways that the formulary wants you to be. So think of your special considerations or your first line, second line, phase A, phase B. If the drug is being used outside of those specific little holes,
right,
then it's technically not a drug on the formulary.
There is a lookup tool on the board's website that you can use to determine where or how the medical treatment guidelines interact with the formulary. I have to be very frank with you, it's not easy to use. And also looking at the tools that are surfaced to the risk professional within the medical portal, which we're going to get to in a minute. Inside that medical portal, it doesn't automatically flag drugs that do not meet the formulary. So this is going to put a lot of burden on us or our PBMs or our risk professionals to really make sure that the drugs are fitting within the formulary. So that's number one. Prior authorization is required when there's a drug just simply not listed in the formulary. I know that sounds quite simple, but I'm trying to spend a moment here just to let us all reflect on the fact that it's actually going to be, let's take some thought to determine if the drug is or is not. The second one is a brand name drug where the generic exists. This is clearly a cost-saving measure. We should be trying to do this anyway through our PBMs, but essentially getting the prescribers to do generics instead of the brand name.
That's going to be an eye-opener too, right? Because ultimately down the line, if the ultimate goal is closing with a settlement that may require an MSA, making these decisions early gets generics on the table and have those costs be extrapolated as opposed to the brand name, which will cost more.
Great point. And we're going to get to it in practical advice, but absolutely we should be using the formulary to price our MSAs going forward. That is best practice. Okay. Next, combination products not in the formulary. So none of these compounded or combo products. I was recently in Southwest Florida driving by pharmacies down there which say we specialize in compounded medications. I'm like, oh boy. So those things are out. That's good for us. And the last thing is using a brand name. And sometimes the prescriber will prescribe a brand name simply because the dosage is different than the dosage that's available in the generics.
Right.
And instead of saying just take 2 5-milligram nonsteroidal inflammatories, they'll want to get the brand name 10-milligram nonsteroidal inflammatory. So in general, that will be allowed, but only if the treating physician, the prescribing doctor, can explain why that's necessary. Last thing is compounds. Compounds, combos, they should all be out. And be on the lookout for combo drugs like the nonsteroidal and anti-inflammatories that have the built-in GERD retardants built in there. You know, the things that are just a combination of like Prilosec, which is over the counter.
A lot of topical creams as well.
Right, and well, that's the compounds, and those are all coming out. So let's be mindful of that. This should help us reduce costs. All right, so now we've got a prescriber who's saying, you know what, I want to get all of these crazy medications into my patient. What's the process that the prescriber has to follow?
Yeah, so there are different levels, right? It's going to start with the first level, and that's where we jump in to actually determine whether or not they're on the formulary. I think it's basic, basic in the sense that structurally it's first, but it is going to be a tough thing to decide, like you mentioned. But from that perspective, it's our way of reading the formulary and deciding whether or not it's applicable, and then whether they follow the guidelines for even making the request.
Right, and so the board has a prior authorization process that's going to follow 3 basic steps. Step 1 is going to be what they call first level review, which is going to be done by the carrier, by the self-insured employer, and that's going to be done internally. We'll talk about how that gets set up in the medical portal. But it does not have to be done by a medical professional. It could be a risk professional. It could be a PBM. It could be literally anybody. There's no requirements. We'll talk about that in a second. Then there's a second level in which the board says a carrier designated doctor can make an opinion about whether or not this drug is necessary. And then finally, if the prescriber really has gotten rejected twice or been partially approved twice, they can now go to the medical director's office. And the board has question mark amount of time to respond, and we'll get to that in a second. All right. So prior authorization, first level, let's talk about it. There is 4 days for us to respond to that first level request. And that is, let me just say this very carefully, that is computer days. So It is 96 hours from the moment that the request goes in, and weekends are included. So I know we're going to get into a lot of ugly circumstances where there's a holiday and somebody's
Right.
on PTO and there's 4 days and now we blew it.
So this is definitely going to have some contention where, an arbitrator or a judge is certainly going to have to make a decision that's going to make this more specific. For now, it's definitely
4 calendar days.
Calendar.
Okay. Our response is due within that period of time. Now, the good news here is the response can come from literally anyone. There are no qualifications required to respond. Then after the 10 days, the prescribing doctor has 10 days to then file a second level review. And that process, we again have 4 days to respond. This time we need to respond with what's been called a carrier doctor. And there's a definition of carrier doctor. I'm going to get to that in a second. When our response is due, if we fail to respond within that 4 days, the drug will be prescribed and provided, and that's it. We have waived our ability to distribute that medication. If the provider or prescriber does not like our response after that 4 days, they can appeal again, and this will be the third and final level of review, which is to the medical director's office. Now, entertainingly, that's where this little flowchart ends, because there is no regulation, ruling, or issue or information about how long the medical director has to respond. In their webinars and their discussions they've been telling us that have been attending, we're going to try to do it in 3 or 4 days. And 3 to 5 days is what they've been saying. So to be determined. Have you ever gotten a response from the board in 3 days?
No, I'd say that'd be a first. I think the medical director's office is certainly something that isn't involved in our usual day-to-day decision making from the board. But at the same time, I think what they're actually expecting is that one of these parties from first and second level is going to make the mistake on a time-specific deadline to have the decision already made.
Agreed. All right, so let's talk about level 1 review first. It's going to be it's going to be done by us, the payer. It's going to be done in our medical our portal. If you haven't logged into the portal yet, and now's the time, we should be going in there. I'm going to talk about the portal in a few minutes. When you go into the portal, you, the risk professional, or your designated PBM or UREC accredited organization can go in there and they will see all of the pending requests. And then there is a whole list of how you can grant, deny, grant in part, all the things that we're going to be doing to look at that request for approval for this medication. Okay. Now, I want to remind everyone that all of the things that we're talking about today can be delegated to another entity. It doesn't have to be the adjuster doing it, and we're going to talk about how that gets done. Final reminders for this level 1 review. There are no qualifications in the regulations or the statute or anything about how the person who does this first line review has to be accredited. This does not have to be a medical professional. This does not have to be a nurse. This does not have to be a doctor. It can be literally anyone. And I want to talk about that nice and slowly and repeat it a few times because that's the number 1 question we've been getting from our clients, right? So let's move along. Next. The level 1 request must include the quantity and number of refills that is going to be requested.
You'd think, right?
The level 1 request, the first level request may not exceed 365 days.
So what that means is essentially if the level 1 request comes in for a quantity and refill that will take over a year, right, to complete, that's an automatic denial. Let's not worry about that. They've already haven't satisfied their burden.
We then have 4 days to respond to that level 1 request. And I'm going to keep repeating 4 days, 96 hours, 96 hours, 96 hours, because it's scary to me. I also want to remind us as payers that we can partially pay for these things or partially approve. This is just like a normal prior approval or MG2 variance request where we can say, yeah, you want 300 chiropractic adjustments? I'll tell you what, I'll authorize 4.
Right. It's actually a great way to end the process there. If you believe there's some validity to the claimant's injury, right, you may want to strategically consider a partial approval just to get you out of the second level, which we'll talk about.
Okay. Now, again, failure to respond in that 4-day period is approval. So we should be prioritizing this, visiting the portal. I'll talk about that in a sec. All right, a level 2 request. So now they've requested this medication. Within 4 days, we responded with either a partial denial, partial approval, or a straight denial. Now our medical provider or prescriber is saying, hello, I still want to get this for my patient. I am doing a second request. They have 10 days. Within 10 calendar days of the denial or partial approval. I haven't seen that broken out into number of hours, but my guess is it's 240 hours.
It's good math.
From the time of our denial, and let's all be thoughtful about that. They need to include all the same information as the first level. They need to explain why they're departing from the formulary, why they're departing from the guidelines, and what they expect the result to be. They must include our response to the first level. Okay, this is important. And the reason I'm going to stress some of these is because how many times do we see defective MG2s, defective optional prior approvals?
All the time, because the burden of proof actually is your best defense of some of these treatment requests, right? Have they considered the guidelines? Are they using the right designated fax number for the carrier? I actually like in this situation to, for our attorneys out there, did you create the record to appeal, right? Like everything that you did properly and procedurally has to be in place for you to get that opportunity at this next level.
Okay. They also have to include some justification for the request, so some reason why they need to depart from the guidelines, and that's very important. Again, we have 4 days to respond to the second.
How many hours is that?
It's 96 hours.
Okay.
And then if we don't respond within the 4 days, again, I hope everyone's getting a little nervous and scared out there, then it is deemed granted. So let's be careful. Last, the level 2 review has to be done by a carrier's physician. Okay, let's define it.
I would say this is probably the most concerning area for our clients because of the 4-day turnaround.
Who do I get who's going to be able to pick up the phone and look at these things? And also entertaining questions involve, well, a carrier physician reviewed it, but do they actually have to sign it? Do they have to actually go into the portal themselves? The board has issued some guidance saying, yeah, they do. They have to log in, have authorization to log in, go into the medical portal and make the changes, but really do they? That's to be determined. So who is a carrier's physician? What does that mean? Definition, 1, they need to be employed by or contracted by the carrier or self-insured employer. Okay, makes sense. You need to have somebody on retainer, somebody that we're going to use, and somebody that's going to be identified in the portal, and we'll get to that in a second. Or they can be employed by a URAC accredited company. So I went into the directory of accredited organizations to find a New York URAC accredited pharmacy benefits manager, workers' compensation benefits manager, and I came up with zeros. If anybody's listening to this who is a URAC accredited organization that is going to do level 2 reviews, please let us know in the questions. I would love to share your information with all my clients who are listening to this. We have literally hundreds of people watching this webinar right now, and I'd love to be proven wrong if there isn't a URAC accredited company. I think this was meant to encourage companies to get URAC accreditation, which my understanding takes 10 to 12 months to do. So
it encourages the people who are going to look up and be prepared, right? Okay. So if you're going to be accredited, then the idea is that if you don't have the retained doctor in-house, then this should be your opportunity to search outside.
Yeah, and again, if there's anybody who is accredited, first off, please let us know in the questions so that we can announce your name or your organization's name.
What is free sales opportunity?
Absolutely. And number 2 is contact URAC because their directory is all screwed up. Last thing, not employed by the Pharmacy Benefits Management Company, so your PBM, not employed by them. They defined your carrier physician as not employed by your PBM, and that's an interesting thing for them to do. Your doctor can't.
It kind of makes sense. I think it really outlines the fact that if a PBM can be that first level reviewer, you don't want that person to be the same person who's doing the second level review. It kind of makes sense, I guess.
Okay, we'll see. All right, third level review, and here's where we're going to get to some laughy parts. First, again, it has to be filed within 10 days of the denial or partial denial with the medical director's office. Must include the first and the second level responses. So that would be their applications as well as the responses. The medical director's office may go out and they have the authority to go out and hire private reviewers to do this reviewing. So it doesn't necessarily have to be a board employee.
Be certain that they will eventually do this, right?
If they haven't already.
They will get so many third level review requests that this will happen.
Okay. Next, if the the medical director agrees that this should not be prescribed, there is allegedly no ability to resubmit that request again, unless there is, quote, a change in conditions. So
very key point. I think here is also where you would want to use the practical advice we mentioned earlier in terms of an MSA. Essentially, if that decision is made by the medical director's office, that document should be used with your MSA submission to get people to have lower cost MSAs.
All right, I'm hoping everybody can hear me. I just got some text saying there's some problems with the audio. I hope it is working. All right, next, implementation timeline. So first, if you're one of our clients, you're getting this week or this month our 2020 calendar. Our 2020 calendar starts in December, and it starts with December 5th saying this is when this thing starts coming into effect. And that means that all new prescriptions need to follow it. We also marked it on the 2020 calendar in June 5, which is a Friday, the next time that we're going to have all refill prescriptions compliant with the formula.
Right. So to make sense of that, essentially, if the claimant has been prescribed a medication prior to December 5th, then the formulary rules won't go into effect for that particular medication. If it's a new drug that has not been prescribed in that case before, then the formulary will apply.
Okay. How are requests received? They're going to be received through the medical portal. The payer or the PBM, whichever is your designated responder, has some very specific responsibilities, and we should be doing these now. If you're our client, you've already heard from us. We've already been communicating with you about making sure that you've done these things, but let's talk about what needs to be done. First, you need to identify the contacts and emails for each level reviewer. For a payer who's doing this all themselves, you need to identify your level 1, level 2 contacts, and those are the people that are going to be making the decisions at level 1 and level 2.
Which is also funny in that section too, they actually allow you to say who you don't want to contact. That's right. Like, don't contact Tommy over there. He's never going to get back to you.
Right. He's crazy. 3, you need to identify your online administrator. That's the person who's going to have access to your account, medical portal account. The most important person you're going to identify in here is your workload administrator. This is the person who, when the requests come in, can funnel them to all of the different reviewers that you've identified in the system as a reviewer. Workload administrator is going to have the most nightmarish task that I can possibly imagine in my entire life, which is you're getting hundreds, maybe thousands, maybe tens of thousands of these requests, and you got to know who's on PTO, who's out today, who's out tomorrow, if they're going to the risk professionals who are maybe assigned to those cases,
right,
and make sure that it's getting responded to in a short period of time. And the same thing applies for the PBM. Again, they need to identify a workload administrator, the reviewer, and then the user administrator. I don't know how that's different from the online administrator, but they're identified differently in the sign-up forms. So how those requests come in are going to be into the medical portal. We're going to have an example of what the portal looks like in a second, and then they have to be attributed or assigned to the correct level of reviewer. That would be within your organization. Of course, the level 2 has to be a doctor. All right, let's do something practical. Let's take a look at the formulary together. I just want to spend a second reading it. We've included it in the handouts. So it's handout time, everybody. The formulary that we're going to look at is just the very first page of the formulary. Obviously, they have some introductory material in the very beginning that you've seen. And I want to take a look together on page number 4, where the formulary actually begins. And we're just sort of looking from left to right across the formulary. So as you look across it, the things that are important are what's the therapeutic category. There's a drop down within the portal that you can type in the name of the medication or the either generic or brand, and it'll tell you where it falls. It'll tell you what the generic name is. And what I'm looking at most importantly is the next several columns, special considerations. Special considerations are listed on the last page, and we talked about it earlier in this presentation. In order to prescribe codeine with acetaminophen, special consideration 1 and 3 has to apply, which is 1, not to exceed a 7-day supply, and 3, short acting only, right?
Right. This is where your detail-oriented first-level reviewer is going to come in and say, well, yes, this may be a formulary drug, but since it's not applied in the right way, it has to come by approval.
Right. And in other words, what we're saying essentially is, yes, under the medical treatment guideline for this body part, acetaminophen with codeine for breakthrough or short pain is allowed. But if the prescription comes in for 14 days or 2 weeks supply, that's an automatic denial, right? And you're saying in there, look, the reason why is the formulary itself says no. The doctor or prescriber will have to give us some sort of special circumstance as to why this person needs breakthrough pain medication for longer periods than is in the medical treatment guidelines and the formulary.
Right. Consider even the column over where we have phase A, phase B, and perioperative. If they're not using it in the way that the formulary wants it to be, that is considered a non-formulary drug.
Right, and in order to really read this formulary and utilize it, if you're not using the one that's online and built into the portal, which is pretty good, the answer is you're going to be using the formulary itself, the medical treatment guidelines, as well as the last page of this formulary over and over and over again. All right, we want to give you some practical advice and some practical problems. We want to talk about what we think it's going to look like, and then we're going to jump into questions. So, potential problems. First, number one to me, is this 96-hour reviewing clock. If there's one thing we've seen everywhere is the abuse of the variance process. And by that I mean doctor wants to get X, Y, and Z surgery done because there's a high fee schedule for it. They file the MG2 variance. We respond to it with a denial. 2 weeks later, they file, or 1 week later, or 24 hours later, they file the same one over and over and over again until we miss it.
Right. It's definitely a deadline and gotcha state, as we've always been talking about. The doctors who have receptionists that call carriers and then find out through a voicemail that the person's out on vacation. Oh, this is the perfect time to send a variance request. It's certainly a problem here that definitely is apparent with the formulary as well.
All right. The next thing I want us to be mindful of when we're counseling our clients to do is to identify contacts, have emails, make sure that we have people in place for that first and second line review. I also need us to be thoughtful about what that workload administrator's job is. That workload administrator's job is really to provide cover for whoever's out. If somebody's out that day, and if you are trying to self-manage, particularly the first level review, and you're trying to pass it amongst your risk professionals, I think this is something we have to be very thoughtful about. That workload administrator is going to have to make sure that when these requests comes in, somebody's responding to it. And remember, weekends count. This is a 4-day calendar day deadline, and weekends can count.
It's definitely a little bit of a change, right? The variance request for a particular case might go to a particular adjuster or risk professional. In this case, actually overburdening them with being the responsive person for the office is going to take a little bit of maneuvering and really change of protocol.
Yeah. Next thing is there is no time in the regulation, no specific time requirement, due date, deadline for the medical director's office to respond. That we're going to see how this plays out over time and how it works. And that's something we'll definitely keep you up to date with as we sort of update people on how this is happening.
Yeah, sure. I mean, no one likes an attorney saying case by case basis, right? You like more specific guidance here, but the issue here is, is your case going to be affected by the prevention of the prescription to the claimant, right? If we know that the prescription is unnecessary or really overbroad, then the timeline before the MDO actually helps defense. Right? It means that the claimant is not getting the medication that he or she does not deserve and presents avenues for settlement leverage or other issues in your case. Yep. If it talks about cases where the claimant actually needs this and you start to begin to wonder whether this dragging fee is actually hurting the claimant, well, workers' compensation is designed to protect the ones that are actually hurt and deny the ones that are not. So then you can make that informed decision at that point.
All right, and last little practical point that we want to make, practical guide. And I think we said this earlier, is we should be now pricing our MSAs using the formulary going forward.
It's almost like we don't work together or something. I figured I got that out of thin air. I promise I did not look at these slides that much.
You're totally good, but you didn't prepare for the presentation. That's a horrible idea.
That's true. All right. I prepare all the time.
Live question and answer. I am now going to open up the question sheet over here and see what you've typed into us. We're going to answer as many of these as we can. I also want to report that this webinar is being recorded, and we will put it up on our website. So that you'll have access to all the questions that are being asked. All right, let's come over here to questions. I hope there are a bunch. All right, I think we have a bunch.
I think we have a record set today.
All right. The workload administrator, can this also be deferred to a PBM as the L1 and L2 reviewers are, or does it have to be a carrier employee? We are getting confusing responses to this question, says Jonathan. It also says he left. So should we answer his question? Let's do it anyway because we're on scholars. Okay. Jonathan, the answer is clearly a workload administrator is identified in the PBM section of the portal. So it does appear that PBM would take on that role of workload as well.
I think it's a matter of contractual nature. I mean, is your PBM willing to do this and do this to the level that you want it to occur?
All right. Charlie asked the question, do both providers and claimants need to be notified of the formulary before December 5, 2019. What will occur if one of the parties alleges that they were not notified?
certainly going to happen, right?
Yeah.
I didn't know this, right? Ignorance is no excuse of the law. This is something that has been implemented and has been discussed since 2017.
Yeah, it's a
very,
statute, so they're stuck with it.
Very bright line rule here. If the formulary applies, it applies.
Yep, absolutely. Same thing as medical treatment guidelines. If the doctor says, I never heard of medical treatment guidelines, doesn't matter. They apply in your case, and you should be treating people there. Cindy asked the question, how can I get a copy of the handout? I am remote. All right, Cindy, when you're looking at us, hopefully on the GoToWebinar control panel, there's a section that says download. You open up or handout. There should be one in there. Let me just check and make sure it is in there. Yes, it is. It's called NYS-drug-formulary-PDF. That's the handout. And if you have a problem with that, Cindy, you can email me. I'll send it to you. Can I ask the question? What is the remedy to the payer if the provider fails to submit an approval request through the portal for a non-formulary medication? Okay, entertaining question. So here I am. I'm the prescriber. I'm not submitting approval requests. I'm just writing these prescriptions. And we're the payer, right? We're not paying for them. So the remedy is essentially that it's not coming into the case. We're not seeing the bill come in, and you shouldn't be paying for those.
Right.
Fair?
It's a fairly simple application with a treatment request via an MG2 or C4 auth. If they request it properly and you deny it, then they have to go through certain circumstances to get it approved. It's going to be similar. If the bill comes in without the approval, you're going to want to deny it.
Okay. John W. asked the question, what party is responsible for getting the loopholes added? All right, so we don't want the loopholes added, but if the loopholes get added, it's going to be added by the requesting prescribing doctor who's saying, hey, this meets this special consideration. That is what they're going to be doing. And particularly, I think they're going to be focused on special consideration 4, which essentially is the catch-all loophole, which is, hey, it's not in the medical treatment guidelines, but my patient needs it. Right?
Sure.
They have to explain it.
I think too the idea or maybe the use of the word loophole can actually lend you to kind of create that idea. But essentially, if they believe that the formulary applies based on this, quote unquote loophole, you still have the option to deny a bill if you believe that it doesn't apply, and then you can go litigate with your best attorneys, obviously.
All right, and Matthew asks a question that is closely related. How should carriers respond to requests for prescriptions when the case is controverted or under appeal? All right, so cases under appeal, you should be responding under normal circumstances. Unless the issue on appeal is the medication itself, generally speaking, medical care continues even though the case may be under a board panel review or appeal. Okay, so that's step 0. But the second part of it is, how do I prescribe to prescriptions when the case is controverted?
Sure, it's, if I could get on a little soapbox for a while, this is kind of where we can make a dent as well, because a lot of times the C8.1b disputed bills come in and they're denied simply for the fact that the case is controverted. Well, what happens if the case after trial gets established? Then all those bills become payable. The idea here is that if you have an alternate option to deny the bill, meaning the formulary doesn't apply or the special consideration doesn't apply, make sure those defenses are known, because those are actually in addition to the fact that the case is controverted.
Agreed.
Strongly if you lose out, then the special considerations come in to save the day.
Yeah, and short answer, Matthew, is you should be denying them. And in fact, inside the medical portal, there is an actual drop-down or a selection you can state that this is being denied because it's controverted, and also the portal should actually alert you in the match. Actually, it doesn't alert the payer, it alerts the prescriber that the case is not established or is controverted status when they are making the prescription. So there are some things built in to alert parties to that. What about patches, asks Joe M. Are they out? In general, yes, patches are out. However, you have to look through the formula to see if there's any specific treatment or special specific discrete patch is allowed in or out.
I would actually caution between making a catch-all term like that. I think it's very commonplace to use those words, and it's very difficult to understand or apply them to the formulary, because what's going to happen is patches will be created with combination drugs or things that may be formulary drugs but are not, to create the understanding that it should be. Just be very careful of what exactly is being prescribed.
All right, Hannah W. asked the question, if a claimant does not wait the 96 hours allowed period for our response to a pharmacy request, and instead either pays out of pocket or seeks treatment at an emergency room to obtain pending medication, do you think we would have a defensible position to argue against being responsible for the bill? Yeah, so if the prescriber is submitting the request for authorization because they know this thing exceeds the formulary and the guidelines, right? And then the claimant goes out on their own and gets the care. Again, this is the reason why you would want to put your specific objections in, despite the fact that they went and tried to circumvent the rules, so that ultimately when the law judge is hearing the case, we can say, look, here's all the reasons why we shouldn't have had to pay for this, despite the fact that they went out and got it on their own or went to the emergency room.
Absolutely.
Right?
I think procedural defenses are our best friend. Certainly because of the recency effect of the formulary, you may actually not get the result you want before a law judge because the law judge isn't necessarily going to be up to date on a new thing. Surprise, surprise. So you may have to go to a board panel level to actually get the decision you want, but at least making the position is going to be our favorable outcome.
All right, next question comes from Joan. He says, does the second level reviewer need to respond on the portal? Answer, yes. All the responses need to be through the portal. And this is going to be an interesting moment. I don't know how many doctors really want to be sitting around whittling answers into this web form that they've developed.
The ambitious ones.
I presume so, but there's no, because the answer is within the form itself, is it a doctor maybe telling someone, this is the reasons to deny it, or here's what my review says, how is that going to be authenticated? But the answer is yes, all of the responses need to be through the portal. The board's been very clear about that. Robert says, the board is over 5 days behind in entering new people, I guess meaning new patients and claims, into the medical portal. Welcome to New York workers' compensation world, Robert. I have never seen, I will say this, I have a great deal of respect for the board recently. I think the virtual hearing process
Just about to
is
say.
amazing.
Just about to
it's
say.
great,
I think
and
it's
wonderful tech. Everything else is a little bit, bail and wire and bubble gum and hope and prayers. We'll see if this is up and running and up to date by December 5 when it really goes live. Sarah says, why is there no option to grant without prejudice on the pre-authorization? All right, so Sarah, and essentially, first of all, there is always acceptance without prejudice option in the workers' compensation world in New York. If you accept a case without prejudice, within the first year, you can controvert or convert the case to a controverted status. In our experience, that generally doesn't really happen, although we do see cases answered as, the Schroyd has box M check that says essentially without liability. Right. In our experience, I think a decision should be made early in the case, whether this is one we are going to dispute and defend, or it's one we're going to accept, instead of waiting. I know that's very difficult, particularly with the payer compliance rules, to make these kind of quick decisions onto whether a case should be compensable or not. But those are our challenges.
Sure, I think it may not be specifically on the form, but the idea of the formulary is cutting off the supply and the dosage at a level, right? It's not meaning you accept a particular drug and that means you've accepted it for the life of the claim, right? The formulary actually intends to cut off supplies that reapproval must be requested.
All right, Kathleen T says, hey Greg, I went to a claims association meeting yesterday. We went over the drug formulary and the board indicates that a clinical person, so I guess meaning somebody with medical background, should review the first level because the doctor gives clinical notes, which they felt an adjuster would be able to address.
Maybe not able to address.
Your thoughts? Okay, so that's maybe good advice. I don't know. I can only tell you exactly what the regulation states, which is that a level 1 reviewer has to have no specific qualification. I would also tell you that some of the best risk professionals I know, sitting in those adjuster chairs out there, are some of the best doctors I've ever met in my life, right? I mean, they know what they're doing.
Right.
And, I mean, we're kind of like amateur physicians as well. So
speak for yourself.
I don't know if you need to have a specific degree or other than, doing this for 20 plus years to sort of know what's in and out. So although that might be a great practice, and certainly I wish all of my clients, all their risk professionals and all of their first line reviewers were well-credentialed medical professionals. I just don't know if it's possible, and I can tell you categorically it's not required. Next, Joan asked the second question. How does the formulary apply to controverted claims? I think we've already answered that one. Marie asks, does an IME company which has a WC board certified MD and is URAC approved function as a level 2 responder? In other words, can they act as a reviewer? Presumably. Yes, absolutely. If you're URAC accredited, if you're a physician, you are absolutely accredited and able to be that level 2 reviewer. Okay, there we go. It's time for a free ad. Liana Shankar says Corvell Corporation is a national company and is URAC accredited in New York, and our New York location is in Central Islip. So Corvell, Corvel, you're our guys. All right. Joe M says, does this affect our old claims where claimants have been on opioids for a long time?
Yes, this is great.
All claims. Now, just remember, please, that we already have non-acute pain medical treatment guidelines, which should be affecting your cases where your claimants have been on opioids and long-acting pain medications for long periods of time. Guess what? It has been essentially neutered by the law judges refusing to really apply or follow the non-acute pain management guidelines, in my opinion. There have not been great outcomes on that. With the non-acute pain management guidelines, we've had great success in getting people into weaning programs, but that's about it. So,
sure, I think the guidelines really give you the basis, but it doesn't prevent the provider from getting past you on the NG2 level where the deadline gotcha analysis really hurts you. The formulary is actually going to help if you have the right application.
Okay, there's a second question here from Suzanne who says, is there an office standard letter that needs to be used to approve or deny a prescription? No. Those should all be done within the portal, and the reasons for the denial should literally be placed into the portal. There is a board form for responding to it, and that is all done through the portal. In level 2, you mentioned that a copy of the response letter needs to be attached. I would like to see an example of a response letter. Right, so that is for the prescribing physician who is saying, hey, my first request was denied, I've got a level 2 request now, and they have to include our initial response to that. So that, and that would be most likely on the board form. Okay, a third question now on does the formulary apply to controverted claims? Suzanne tells me, Greg, attachment did not come through. Can you send it to me later? Okay, we'll get to you. I see you, Suzanne. Hi. Alicia says, I also missed the email with the handout materials. Nope, the handout materials are actually in the webinar control panel that should be on your computer right now. You should be able to download them. Anybody who has a problem, I will certainly email them to you. Maureen asked a kind of interesting question. Greg, what happens if we deny a drug by mistake? Do we ever make mistakes, Mr. Cizon?
No, of course not. But
No.
if you want to revert a denial, simply call the doctor's office and approve it. Out of court gets you out of the process. I'm sure the medical director's office would love that.
Right. Next, Adria asked a question. If a prescription is prescribed pre-surgery, so I'm going to presume that this is a perioperative medication, and the claimant decides not to have surgery as scheduled, but was still provided the medication. Okay.
This is great.
This is weird. And then the claimant decides at a later date she wants the same medication to be prescribed and approved again based on the surgery being rescheduled. So here we have someone being prescribed perioperative drugs, apparently takes them, doesn't get the surgery, has a great weekend enjoying these major painkillers and white wine, and now cancels the surgery and then does it again. I mean, at this moment, Adria, I think I would be denying these things and also probably putting that person under surveillance because they're having too much of a good time. So not to be too flippant, I think ultimately the board would probably reapprove those perioperative drugs if they are going to then finally have that surgery that second time when it's actually rescheduled.
We are halfway through the questions, by the way, which is great.
There are so many questions. You know. This is awesome. All right. Suzanne asked the question, on the 96 hours, is the provider only going to request this via the portal, or are they required to send us something in writing, paper form, mail, or fax? Okay, so here's the scary moment. Nope, it's only through the portal. That's the only place they have to request this stuff. It should be all digital. There should be no mailing, faxing, or paper, which means that workload administrator and those level 1 contacts really need to be checking the portal every day.
Right.
Right. And the portal, by the way, will alert you. It is also sortable, so you can sort it by most latest requests, earliest requests, most pending requests, those types of things. All right, Ken asked the question, is the payer required to list all medications on provider notification letters? If yes, can they include both formulary and non-formulary medications? So I'm not sure exactly what this question is asking. Is the payer required to list all the medications? As far as I know, any medication that's being requested by a prescriber has to be done through the portal. The portal organizes the requests by any criteria you want. And that could be by the patient. That could be by the claim number. That could be by the board number. So if you're asking, is there an easy way for me to see every prescription that's coming in just for this one claimant? Absolutely. And for multiple physicians, you can sort that in the portal. If you wanted to sort the portal and say, I only want to see requests for medications from this one doctor, I think that can also be done. I think you can also sort in that way as well. So I hope that answers your question.
I'd also be mindful too, if it's a true formulary drug, you might not see a request for approval, right? You might get the bill because it's truly on the formulary. You would have the option to deny the bill if you believe that's not on the formulary.
All right, Rachel A asked the question, if the formulary states it's, quote, second, close quote, how do we know what drug should have been tried first? All right, so the formulary does identify drugs as second-line drugs. All of those second-line drugs should only be requested after a first-line drug has proven to be ineffective or there's a comorbidity there. So two things are going to happen. One, you have to check the medical treatment guidelines to determine what is the first-line drug, what's the phase A drug, what's the first one that they should have been taking. Second, in the request for the second-level drug, the doctor has to tell you what the first-level drug was that wasn't efficacious or had an interaction or aggravated a comorbidity. So that's where you'll be able to determine exactly what was the first one and why did it get skipped or why was it ineffective.
Yeah, I'm sure. I think that's actually going to come up more when a second line drug is being prescribed first before anything, right? Because typical providers will just, their drug of choice or whichever pharmacy rep they like that particular day is going to use a second line drug before a first line drug is actually tried.
All right, here we got, it's our old pal, Leonard.
I think he actually likes when we name him in the webinars.
Hi, Leonard. All right, so Leonard asked the question, if I request an IME to address a non-formulary issue, okay, non-medication issue, can I have the examiner address prescriptions in addition to the specific issue? Okay, let's full stop here. Yes.
Yes.
The formulary does not change your right to have your independent medical evaluator look at the entirety of the treatment course. Whether it complies or doesn't comply with medical treatment guidelines, whether it complies or does not comply with the formulary makes absolutely no difference. Your IME always has the opportunity to question, review, consider the entire course of care. So that's number one. And then Leonard asked, but is that a backdoor for the carriers to address prescriptions approved due to timeline issues? Yeah, absolutely it is. So in other words, hey, I blew the 96-hour timeline. Whoops, now this person's on this crazy medication. Can I have it still reviewed by an IME? Yeah, absolutely, right? Just like you do not lose the right to have a medical review ever. All right, I'm going to kill this name, Chinyanwa.
Sorry?
Okay. Are we still held by the same time frame if the request is received on an MG2? Chi-Chi.
Well, that's a good question. That's a great question, actually. So the MG2 will give you that timeline that we're used to seeing, but the formulary now creates your burden of proof defense, right? If the formulary drug actually should have been requested for approval according to the rules of the formulary, that is an automatic denial based on burden of proof. That would then have to be a 15 calendar day denial.
Okay, Alicia says, where is this portal located? All right. If you haven't logged into the portal yet, or you haven't been talking about this within your claims organization, and now's the time, the portal is located the same place that eCase is located. It should be one of your electronic CIS available services. Again, you have to be registered and authorized to use the portal, but it's the same thing or the same way you would log into eCase. Okay.
You'll get used to it. I mean, my search history of the past year just says drug formulary. So,
right. Lots of requests for drugs. That's kind of weird. Keely asked the question, what happens in cases where the pharmacy does not process a prescription through our PBM, and we don't know about the medication until we get the bill? Okay, again, you should win, because it should all be going through the portal.
Right, deny the bill.
Yep. Chi-Chi asked the question, also, if the request was not addressed within the time frame, does that mean automatic approval?
Yes, it does.
Sorry.
That's the first problem we have, right? The 96 hours have to be on top of it. If we don't, that's going to be the gotcha aspect of it.
All right, June asked the question, Greg, can anyone upload determinations to the portal for level 2 as long as it's provided by a reviewing physician? Yeah, it seems to me that's how that's going to work. The board has issued guidance in both their webinar that they did, as well as their frequently asked questions, saying that the physician reviewing the request should be logging in and typing in their answer. But it seems to me like there's no way of authenticating or proving that. And it does seem to me like, particularly if they're going through a lot of these in a row, that it could be done by administrative staff. Again, to me, that's unclear as to how they're going to authenticate that it was actually the reviewing physician or not. Somebody whose name starts with a G and says, "Don't use my name since it is so unique." Are claimants allowed to put their narcotics under their private health now? No. Certainly they do it, right? Do they go out and get prescriptions filled outside of the workers' compensation system because we would never provide this within the workers' compensation system? Yes, but that should never become your liability or exposure. And will we as carriers get the health insurance match program for reimbursements? Yeah, so this doesn't affect the HIMP program in any way. So if you do have HIMP requests that are going back and forth between different carriers, this shouldn't be a problem or shouldn't affect that. Jennifer says, if we are denying the request for authorization through a portal, does a C-8.1A need to be filed? I don't think we've seen any guidance whatsoever on that. My understanding is that the prescriber will get their notification through the portal on their end, which also triggers them, hey, do you want to file an appeal of this or not?
Right, that's a great question. We get the request through the portal. The doctor's going to get it back through the portal. You don't have to do anything official other than comply with the portal requirements and the timeline.
Yeah, and you know what? Let's look into that answer for you, because I think that's one for us to circle back to. To me, as a belt and suspenders type of attorney, I think I would still do a C-8.1A just to cover my butt, but there doesn't seem to be any reason. There has to be guidance on this. I might have
Sure.
missed it.
A lot of times C-8.1As are purely for notice purposes, right? If a claimant doesn't attend an IME and you want to let a provider know that you're not going to pay their next bill because the claimant didn't see your doctor, then a C-8.1A just provides them notice that you're not going to pay the bill. So it's not going to hurt you.
Okay. We're going to do one more question because we've now been at this for about an hour, and we're only about 2/3 of the way through the questions. So maybe we should do a poll whether people want us to stay down and answer questions, or we should just do the rest over email. But
Ken probably won't get that till the end of the list.
Right. So, is the board member required on the provider claimant notification letters? There are not going to be any of those. This is all going to be done through the portal, which is absolutely done that way. Chichi asked the question, is there any current argument for establishing the time frame to be business days? I don't know, just common sense. Yeah, it should be. Diana says, what happens with claimants who purchase prescriptions out of pocket or put through private insurance? I think we've answered that a few times. Jillian says, what is the portal and where is it found? Who maintains this portal, Greg Lois? All right, so besides being a really cool video game called Portal, there is a medical portal that is now going to be accessible to everyone who's registered through the Workers' Compensation Board. It is the same way you get to eCase. And by the way, guys, if you're out there doing New York workers' compensation claims, we should be getting familiar with the portal now. This is the time. You've only got a few weeks. Sarah says, Greg, the specific URAC accreditation needed is IRO. Okay, that's news to me. I was looking up beneficiary manager or workers' compensation manager, so okay, maybe there are many more. And Sarah then also tells me, Greg, Corvell is the only company that has the workers' compensation utilization URAC management accreditation. Congratulations, Corvell.
Go Corvell.
Woo. All right, Robert says most companies that do UR that are URAC accredited in New York will be able to do this. Our UR company, Genex, is going to be our level 2, so it sounds like there's a second one. And also says, hey guys, there also is a lidocaine patch on the formulary. Okay, so there's a specific there. Thank you, Robert. Okay, Derek says, Derek Prochnow says, in a prior webinar put on by the AIW board, they said the level 2 reviewer needs to be licensed in the state of New York. Regulation 44.1G does not require them to be licensed in New York. Can you clarify whether this is a requirement? Yeah, it says physician authorized to practice law. Practice medicine. So that's what the actual requirement states. Liana says, claims adjusters are not clinicians. How will they be able to provide a medical reason for denial, question mark. Also, if the doctor forgoes the process and simply prescribes the medication and ends up at the pharmacy, will there be a penalty if the carrier chooses to approve medication at that point, question mark. So if they're bypassing the portal, Liana, that's going to be a problem, and they should not be held responsible to pay for it. Neither the claimants nor the prescribers or the pharmacies are going to be allowed to bypass the portal. The board's goal is to focus all of the requests for prescriptions regarding all patients that are covered by a workers' compensation claim through this medical portal. All right, it's at 1 o'clock, it's at an hour, and we're seeing attendance drop down. We've now dropped down to below 200 people. There are a number of additional questions, and the people we didn't get to yet, Mary Jo, Sean, John, Jacqueline, Alana, Derek, Joe, there's a whole bunch of people asking us questions.
To stay on.
Some of them just saying, stay on. We're going to email you back answers. Maybe we'll have another webinar on this topic because
Just Q&A.
We're just Q&A because this is seeming like a topic that there needs to be some more clarity built around. Again, my name is Greg Lois. I'm joined today by my partner, Christian Cison from LOIS Law. Thanks for joining us today. This was fun for us. I hope it was fun for you and informative. All right, everybody, have a great day. See you soon. Bye.